Guardians of Integrity, the crucial role of False Claims Act defense attorneys. The law firm of Watson & Associates LLC defends government contractors, manufacturers, and healthcare clients throughout the United States from federal False Claims Act allegations. We aim to minimize adverse actions, vigorously defend civil and criminal cases, and avoid costly legal mistakes. In the complex world of government regulations and healthcare billing, even unintentional errors can have severe consequences. The False Claims Act, or FCA, stands as a powerful tool against fraud, waste, and abuse. It impacts a wide range of industries, holding individuals and corporations accountable for fraudulent activities against the government. Navigating the intricacies of the FCA requires specialized legal expertise. This is where a skilled False Claims Act defense attorney becomes indispensable. Allegations of FCA violations can lead to significant financial penalties, reputational damage, and even criminal charges. Having a seasoned legal team by your side is not just an option, it is a necessity. They can help you navigate investigations, build a robust defense, and protect your rights every step of the way. Early intervention is key. The sooner you involve a False Claims Act defense attorney, the better positioned you are to mitigate potential damage. Their expertise can mean the difference between a swift resolution and a protracted legal battle. Unveiling the statute. Understanding 31 U.S.C. Section 3729, 3733. At the heart of the False Claims Act lies 31 U.S.C. Section 3729, 3733. This section of the United States Code outlines the prohibited actions, penalties, and procedures related to false claims made against the government. Understanding its provisions is crucial for any individual or entity that interacts with government programs. Section 3729 defines the core elements of a False Claims Act violation. It prohibits knowingly presenting or causing to be presented a false or fraudulent claim for payment or approval. This includes making false statements to avoid paying money owed to the government. The statute casts a wide net, encompassing a range of fraudulent activities. Section 3730 outlines the provisions allowing private citizens, known as relators, to file lawsuits on behalf of the government. These whistleblowers play a vital role in uncovering fraud and are entitled to a portion of any recovered funds. The high stakes of non-compliance, severe penalties, and reputational damage. The consequences of violating the False Claims Act extend far beyond financial penalties. The reputational damage alone can be devastating for individuals and businesses alike. The stigma associated with fraud allegations can erode public trust and impact future business prospects. Government contractors found in violation of the FCA face severe consequences. They may be barred from participating in future government contracts, effectively shutting them out of a significant revenue stream. Healthcare providers are not immune to the FCA's reach. Hospitals, clinics, and individual practitioners can face significant penalties for fraudulent billing practices, such as upcoding, unbundling, and providing unnecessary services. These violations can result in hefty fines, exclusion from Medicare and Medicaid programs, and even criminal charges. The FCA's whistleblower provisions add another layer of complexity. Employees, contractors, or anyone with knowledge of fraudulent activity can file a lawsuit. Seeking legal counsel from a seasoned False Claims Act defense attorney at the first sign of trouble is crucial. Navigating the labyrinth. Why you need a specialized legal advocate. The False Claims Act is complex, requiring specialized legal skills. A specialized attorney brings in-depth knowledge and experience. This expertise is crucial for crafting a tailored defense strategy. They understand agency workings and can navigate investigations. Choosing the right legal representation is paramount. Healthcare under scrutiny. Unique vulnerabilities and defense strategies. The healthcare industry faces unique vulnerabilities under the False Claims Act. Understanding potential pitfalls and proactive defense strategies is paramount. Medicare and Medicaid billing is a common area of scrutiny. Overbilling, upcoding, and unbundling can trigger FCA liability. Pharmaceutical companies face allegations of off-label marketing and kickbacks. Medical device manufacturers face scrutiny for defective devices and fraudulent claims. Implementing robust compliance programs and regular training are crucial. Government contractors on guard avoiding pitfalls in a complex regulatory landscape. Contractors operate in a highly regulated environment, subject to myriad rules ensuring transparency and accountability. The False Claims Act poses significant risks for non-compliance. Misrepresenting qualifications to secure contracts is a common pitfall. Inflating experience or falsifying certifications can have serious consequences. Accurate information is crucial for awarding contracts. Cost mischarging is another risk area. Contractors must meticulously track and report costs. Inflating labor hours or submitting false invoices can lead to allegations. Subcontractor management requires caution. Ensuring subcontractor compliance with FCA regulations is crucial. Implement robust compliance programs to mitigate risk. Case study: a cautionary tale of False Claims Act litigation. In 2023, a major pharmaceutical company agreed to pay a staggering $2.8 billion to settle allegations that it illegally marketed a drug for uses not approved by the Food and Drug Administration. This landmark case serves as a stark reminder of the potential consequences of violating the False Claims Act. The lawsuit, filed by a whistleblower under the provisions of the FCA, alleged that the company engaged in a widespread scheme to promote its drug for off-label uses. The government's investigation revealed that the company's actions resulted in millions of dollars in fraudulent claims submitted to Medicare and Medicaid. The settlement included a criminal fine of $1.3 billion and civil settlements with federal and state governments totaling $1.5 billion. The case serves as a cautionary tale for all companies operating in industries subject to FCA scrutiny. Case study: when healthcare practices lead to legal battles. In 2022, a national healthcare provider network agreed to pay $18 million to resolve allegations that it submitted false claims to Medicare for medically unnecessary cardiac procedures. The case, initiated by a whistleblower lawsuit, underscores the importance of robust compliance programs and the potential consequences of failing to prevent fraudulent billing practices. The whistleblower, a cardiologist employed by the provider network, alleged that the organization pressured physicians to perform unnecessary procedures to increase revenue. The government's investigation substantiated the whistleblower's allegations, finding that the provider network submitted thousands of false claims to Medicare over a period of several years. The settlement included a significant financial penalty and a corporate integrity agreement requiring the provider network to implement comprehensive compliance reforms. This case highlights the critical role that whistleblowers play in uncovering fraud and abuse in the healthcare industry. Case study: government contracts and the price of non-compliance. In 2024, a major defense contractor agreed to pay $45 million to settle allegations that it violated the False Claims Act by inflating costs on a government contract. The case, which involved the development of a critical military aircraft component, demonstrates the severe consequences of misrepresenting costs and failing to comply with government contracting regulations. The lawsuit, filed by a former employee under the provisions of the FCA, alleged that the contractor knowingly submitted inflated cost estimates to the government. The government's investigation confirmed the whistleblower's allegations, finding that the contractor's actions resulted in millions of dollars in overpayments from the Department of Defense. The settlement included a substantial financial penalty and a suspension from government contracting for a period of 1 year. This case underscores the importance of accurate cost accounting, transparency in government contracting, and the critical role that whistleblowers play in holding companies accountable for fraudulent activities. The Watson & Associates Advantage: your shield against False Claims Act allegations. Facing accusations under the False Claims Act can be daunting. The stakes are high, the legal landscape is complex, and the potential consequences are severe. At Watson & Associates LLC, we understand the challenges you face and stand ready to be your steadfast legal advocate. Our team of experienced False Claims Act defense attorneys possesses a deep understanding of this complex area of law. We have the investigation and trial experience necessary to defend clients in a wide range of industries, including healthcare, government contracting, and pharmaceuticals. Our attorneys will work tirelessly to investigate the allegations against you, identify potential weaknesses in the government's case, and develop a comprehensive defense strategy tailored to your unique circumstances. At Watson & Associates, LLC, we are committed to protecting your rights. We are unwavering in our commitment to safeguarding your legal rights and ensuring that you are treated fairly throughout the legal process. Safeguarding your future. Take action today. If you are facing allegations under the False Claims Act, do not delay in seeking legal counsel. The sooner you act, the better positioned you are to protect your rights and mitigate potential damages. Contact Watson & Associates, LLC today at 1-866-601-5518 for a confidential consultation. Remember, in the face of FCA scrutiny, knowledge is power, and experienced legal representation is your strongest defense.